Hi, everyone. We're going to get started in 1 second. People are joining and the webinar is populating. We're so glad that you've joined us today for our webinar. All right. Thank you for attending our webinar on Indian law cases decided by SCOTUS this term, a primer. This panel is sponsored by the ABA section on civil rights and social justice and is one of many in a series of rapid response webinars. We're actively planning additional programming on a variety of issues, so please visit americanbar.org/CRSJ for updates on these programs. My name is Patty Ferguson Bohnee. I'm the co-chair of the Native American Concerns Committee, which is part of the section of Civil Rights and Social Justice. I'm also the faculty director of the ASU Indian Legal Program. I'm participating today from the lands of the Akimel-O'odham. I'm honored to moderate this distinguished panel, which will focus on 3 Indian law cases decided this term by the U.S. Supreme Court. They touch on fundamental concepts at the core of federal Indian law. We'll have a brief overview of the term and a discussion of these cases and their impact on broader federal Indian law principles. I want to thank our panelists in advance for their participation and for their work to protect tribal sovereignty. Our panelists today include Erin Dougherty Lynch. She is the senior staff attorney and the managing attorney of NARF's Anchorage, Alaska office. She works on a variety of federal Indian law issues, including Indian and tribal child welfare, subsistence, co-management and co-stewardship agreements, voting rights, tribal jurisdiction and sovereignty, tribal sovereign immunity, and issues related to Alaska Native communities and climate change. She is counsel of record in the tribal amicus brief in Holland versus BRACKEN, which included 497 federally recognized tribes and 62 tribal organizations. We also have Lenny Powell, who's a senior associate at Jenner & Block. He focuses in appellate and Supreme Court practice and Native American law. He represents clients before appellate and trial courts throughout the country in cases raising high-stake issues of constitutional and statutory interpretation, administrative law, criminal procedural, and federal Indian law. He's also a former tribal leader, and he clerked for Judge Howe on the Federal Circuit for the District of Columbia and Judge Ide on the 10th Circuit. He's part of the team that represented the tribal defendants in BRACKEN versus Holland. We also have Shah Deveretsky. He's the partner and head of the Supreme Court and appellate practice at Skadden Arps, Slate, Meagher, and Floam. He's argued 17 cases in the Supreme Court, 3 during the most recent term, including on behalf of the Navajo Nation, Arizona versus Navajo Nation. He clerked for Judge Ludy on the 4th Circuit, who was recently appointed the co-chair for the ABA Task Force for American Democracy, and he also clerked for Justice Scalia of the U.S. Supreme Court. We have also Pratik Shah, who's a partner at Akin, Gump, Strauss, Hauer, and Feld, and he's head of its Supreme Court and appellate practice. He's a former assistant to the solicitor at DOJ, and he clerked for Judge Willie Fletcher on the 9th Circuit and Justice Stephen Breyer on the U.S. Supreme Court. He's argued cases in every circuit in the United States and 17 cases before the U.S. Supreme Court, including Lac de Flambeau, Band of Lake Superior Chippewa Indians this past term. Finally, we have Matthew Fletcher, who's a professor at Michigan Law. He is a Chief Justice for 3 tribal nations and appellate justice for 10 tribes. He's a leading scholar in federal Indian law and tribal law. He has numerous publications, including case books, horn books, and his scholarship has been cited by the U.S. Supreme Court. Most recently, he was a lead reporter for the American Law Institute's Restatement for the Law for American Indians. We have wonderful panelists, and I want to thank them for their participation. The links to the bios will be on our webinar page, and they have been put in the chat. A few housekeeping items. During today's program, we encourage you to ask questions through the Q&A, not the chat function. If you do not see the controls, please ensure your screen is not idle. I will be monitoring the Q&A, and we will do our best to address your questions, time permitting. Please don't wait until the end of the program to ask your questions, as we will try to address questions after each case discussion. We will also be sharing a recording of this program with everyone who has registered so that you can share it widely with your networks. So with that, let's get started. First, we're going to have Erin Lynch provide context to our discussion and broadly introduce the decisions this term and provide some background on core Indian law concepts.
Wonderful. Thank you so much for that lovely introduction. And it's really great to be here with you this morning for the folks who are in Alaska and Hawaii, and this afternoon for folks in the rest of the country. I'm Erin Lynch. I'm a senior staff attorney at the Native American Rights Fund. And to get things going, I'm going to provide a bit of context to introduce the three cases that the court heard this last term. And in doing that, I'm going to introduce some of the foundational concepts of federal Indian law, just to help lay the groundwork for a more detailed discussion that is going to come later. So, starting sort of from the beginnings of federal Indian law, tribal nations have been in what is now the United States since time immemorial and are sovereigns that predate the founding of this country and the United States Constitution. And I know it might, for some folks who are on the line who might be experienced or practiced in federal Indian law, it might seem a little odd to start so early or so foundational, but I also understand that we have a variety of experiences on the line today. And so just trying to lay that groundwork and to build everyone's understanding. The federal government had both economic and political incentives to formalize a government-to-government relationship with tribal nations, and the United States furthered its policies of removal and relocation of tribal nations by relying on the use of treaties and agreements that were ratified by Congress. In recognition of the immense consideration provided by tribal nations in these agreements, as well as their status as sovereigns, a series of interpretive rules known as the Indian Canons of Construction have developed over the last 2 centuries of Supreme Court precedent. Under these canons of construction, all treaties, agreements, statutes, executive orders, and other enactments that affect the rights of tribal nations must be interpreted in light of the parties' intentions, with any ambiguities resolved in favor of tribes. So in short, treaties between the United States and tribes are liberally construed in favor of tribes. There has long been a tension between tribes and states, and in drafting the United States Constitution, the framers well understood this tension and reserved for Congress what is often called plenary power that is not absolute, but that is relatively broad as it relates to tribes and Native people. The primary source of Congress's authority is the Indian Commerce Clause, which provides Congress with the power to, quote, regulate commerce with the Indian tribes. And both Congress and the United States Court have consistently understood that power to extend to a broad range of affairs, from economic activity to housing, health, education, and beyond. These laws are not racial in nature, but are instead grounded in the political relationship between the United States and tribal nations. Tribes continue to possess inherent sovereign authority over their members and territories. And as separate sovereigns, tribes retain their historic common law sovereign immunity from suit. Tribes themselves may waive their immunity, and Congress may abrogate that immunity, but it can only be accomplished by clear, express, unequivocal language that conveys a clear statement of Congress's intent. Treaty-based rights and tribal sovereign immunity, again, are only deemed diminished by clear and express acts of Congress. So turning to the 3 cases that the court heard this term, I'm just going to briefly mention the issues in each of them that correlate to these foundational principles that I mentioned. In Holland v. BRACKEN, the issue in that case was the constitutionality of the Indian Child Welfare Act. Congress passed ICWA nearly 45 years ago in response to a crisis of Indian child removal, first by federal policies and later by state child welfare agencies. BRACKEN was a unique case in that there were a number of foundational constitutional doctrines at issue in that case, each with varying sub-arguments. So there is a lot of briefing, and oral argument lasted nearly 3 hours. Broadly, those who were challenging ICWA argued that it was unconstitutional because First, their argument was that ICWA did not fall within Congress's enumerated powers. They also argued that ICWA impermissibly commandeered states and thus violated the 10th Amendment. They also argued that ICWA is a law that is based on race and thus violated equal protection rights. And then they also argued that ICWA violated the non-delegation doctrine. My plan wasn't to go too much into the actual meat of the case. I would like to save that for my other panelists, but I'll certainly jump in and help in those conversations later if there's time. The next case we're going to hear about today is Arizona v. Navajo Nation. And this case addressed the Navajo Nation's breach of trust claim against the United States for failing to appropriately manage the nation's reserved water rights, specifically in the lower basin of the Colorado River. At issue in the case were the nation's treaty rights and the Winters Doctrine, which recognizes and gives effect to the promises made by the United States in treaties, again, congressionally ratified agreements and executive orders that tribal nations would retain permanent and viable homelands. Then finally, in the Lac de Flambeau case, the court addressed the doctrine of tribal sovereign immunity as it relates to the US Bankruptcy Code. As I mentioned a couple minutes ago, Indian tribes are separate sovereigns that existed before the Constitution and continue to exercise their historic sovereign authority. Like all sovereigns, tribes enjoy the traditional common law immunity from suit, but in the tribal context, tribal sovereign immunity serves distinct tribal interests by promoting self-sufficiency and economic development. Tribal businesses, which tribal sovereign immunity also protects, are essential to achieving those goals, given the challenges that tribes face raising revenues through other traditional means like taxation. So I will pause there. I would just one more comment sort of to briefly contextualize the court's last term, but I don't want to get too far ahead or jump in on any comments that Professor Fletcher might make. But before turning it over to my colleagues, when I think of sort of the trajectory, of the court's Indian law cases, I would just like to note that the trend that we have all seen sort of broadly in the cases that the court has been taking lately, there's a theme of cases where litigants are coming to the court and asking it to overturn or radically reinterpret precedent that has existed sometimes for centuries. And that movement has extended into Indian law cases as well. Specifically in BRACKEN, which I'll just mention and then turn it over to my co-panelist, the petitioner's arguments, if successful, would have drastically reduced Congress's authority, disrupted the power dynamic between states and the federal government, disrupted the relationship between the federal government and tribal nations, and broadly undermined entire areas of law, such as federal Indian law and child welfare law. So this broad effort to restrict the powers of Congress and federal agencies has been very present in these Indian law cases that we've seen these last few terms, and will continue into cases that we will all encounter in the court's next term, which starts on October 1st. So I will pause there and turn it over to my co-panelists, but thank you so much for your time and for having me today.
Thanks, Erin. Thank you so much for that context and that overview. We appreciate your contribution and hope that you will participate in the discussion. Next, we'll turn to Lenny so he can discuss BRACKEN. So Lenny, whenever you're ready.
Thank you. And, we already got a really great high-end summary, but I'll try to get into some of the details. Thank you for having me. I'm very glad to be here today to talk about the Indian Child Welfare Act, also known as ICWA, and this term's major victory for Native American tribes in Holland v. BRACKEN. As was noted, I was one of the attorneys who litigated BRACKEN on behalf of the tribal parties. I'm pinch hitting today for the head of our appellate group, Ian Gershengord, who argued the case. Ian wishes he could participate, but unfortunately he's tied up dropping his son off at college today. So I'll touch on four things during my section. First, I'll talk a bit about what ICWA is and why it was enacted. Then I'll explain how the BRACKEN case arose and discuss the arguments that the challengers raised. After that, I'll go through the court's holdings. And finally, I'll briefly give my take on the broader significance of the ruling. So to set the table, passed in 1978, ICWA was the culmination of the federal government's practices and policies with respect to Indian children over the course of 2 centuries. From the very start of the Republic, Indian children were central to the United States' relationship with Indian tribes. For instance, the first treaty that the United States ratified committed the United States to ensure the security of the children of the Delaware, and in the ensuing decades, to achieve so-called civilization of Native Americans, the United States extensively funded Indian education. Indeed, 110 Indian treaties provided for Indian education, and some treaties contain provisions specifically addressing the care and guardianship of Indian orphans. When federal policy turned toward assimilation after the Civil War, the United States became especially focused on Indian children. In one of the darkest periods of our country's history, the federal government forcibly removed Indian children to boarding schools with the philosophy, kill the Indian and save the man. That broader policy goal continued into the termination era of the 1950s, though the federal government's preferred means of achieving that end evolved. During this period, the federal government endeavored to terminate its supervisory responsibilities for Indian tribes. To do so, among other things, the federal government closed most boarding schools and instead sought to transfer responsibility for Indian children to the states. Now, states initially tried to disclaim authority for Indian children. They maintained such children were the federal government's responsibility, primarily because they did not want the funding issues that came with these tasks. But states eventually did accept the federal government's invitation, and the consequences for Indian tribes and families were devastating. States designed their laws to facilitate the removal of Indian children to non-Indian homes. They did so because placing Indian children with wealthy non-Indian families saved states money. Moreover, states sought to satisfy escalating non-Indian demand for Indian adoptees. The result was a wholesale removal of Indian children that by 1970 was described as, quote, the most tragic aspect of Indian life. The 1970s, however, proved to be a period of change. Federal policy finally supported tribal self-determination. And one of the major efforts Congress initiated during this era was convening hearings to investigate the crisis of the removal of Indian children. Congress's hearings detailed the impact on the tribes themselves of the massive removal of their children. Congress found that abusive child welfare practices resulted in upwards of 1/3 of Indian children being separated from their families. In addition, Congress determined that the state actors who removed Indian children often had no basis for intelligently evaluating the cultural and social premises underlying Indian home life. Indeed, many of the state actors were at best ignorant of Indian cultural values and at worst contemptful of the Indian way. Such actors were convinced that removal, usually to non-Indian households or institutions, would unequivocally benefit Indian children. The result of those practices, Congress concluded, was wholly inappropriate decisions, finding neglect or abandonment where none existed. And the impact on Indian tribes, families, and children was devastating. Due to the operation of state law and state courts, more than 1/4 of Indian children were torn from their families and tribes, and approximately 90% of placements were non-Indian homes. In response to these shocking findings, in 1978, Congress, with overwhelming bipartisan support, enacted ICWA to address this crisis. ICWA is based on a simple idea. When Indian children can stay with their families and communities, tribes and children alike are better off. Indeed, today, ICWA has become the gold standard for child welfare and has staunched the flood of unwarranted removals of Indian children from their homes. One of the ways ICWA has done this is by establishing minimum procedural and substantive rights that apply in state court child custody proceedings involving Indian children. Procedurally, ICWA requires notice when an Indian child is subject to an involuntary proceeding seeking foster care placement or termination of parental rights. In such involuntary cases, the parties initiating the case must provide notice to parents, custodians, and tribes which have intervention rights. On substance, ICWA combats the ignorance and contempt that spurred its enactment. To start, ICWA contains an active efforts provision that requires any party seeking a foster care placement or termination of parental rights to satisfy the court that active efforts have been made to prevent such foster care placement or termination. In addition, ICWA sets placement preferences that apply when such involuntary placement becomes necessary. Most notably, it provides adoptive placement preferences to 1, a member of the child's extended family, 2, other members of the Indian child's tribe, or 3, other Indian families. State courts, however, may depart from these preferences for good cause. So with all that background in mind, we can turn to the BRACKEN case itself. The case has a lengthy history going back to 2017, but the basics are that the BRACKEN couple and other individuals who said they wanted to adopt Indian children filed in the Northern District of Texas a federal suit against federal officials seeking to have ICWA declared facially unconstitutional. Texas, Louisiana, and Indiana joined the challenge, though of those states, only Texas ultimately pressed the challenge before the Supreme Court. The United States and 5 intervening tribes defended ICWA's constitutionality. In the lower courts, the Fifth Circuit went en banc and largely upheld ICWA, but the decision was fractured. There were 325 pages of opinions, there was no single majority opinion, and on some issues, the en banc court split perfectly 8-8. So the Supreme Court granted cert. At the court, the case presented 5 sets of issues, though you can parse these a number of ways, but I'll count them as 5. First, whether Congress possessed authority to pass ICWA. Second, whether the challengers had standing to challenge ICWA on equal protection and non-delegation grounds. Third, whether ICWA comports with the equal protection component of the Fifth Amendment's due process clause. Fourth, whether ICWA violates 10th Amendment anti-commandeering principles. And fifth, whether a provision of ICWA that allows tribes to reorder ICWA's placement preferences violates the non-delegation doctrine. Now, since our topic today is Indian law, I'll focus primarily on the Article I and equal protection issues. The challengers' broadest arguments on these fronts attempted to rewrite the very fundamentals of federal Indian law in ways that would have completely upended settled understandings going back to the founding. Starting with Article I, the challengers here picked up an argument that Justice Thomas articulated in concurring opinions in 2 previous Indian law cases, United States v. Laura and Adoptive Couple v. Baby Girl. By way of background, the Supreme Court has long held that Congress possesses plenary power over Indian affairs, but the challengers argued essentially the opposite. They maintained that Congress does not have complete power over Indian affairs because the federal government is a government of enumerated powers and because there is no so-called plenary power provision in the Constitution. The challengers focused in particular on the Indian Commerce Clause. They maintained that that clause is the primary source of Congress's power with respect to Indian tribes, and they argued that the Indian Commerce Clause extends only as far as the Interstate Commerce Clause in terms of the powers it confers on Congress. The challengers also acknowledged that the Treaty Clause can be a source of power with respect to Indian tribes, but they maintained that the Treaty Clause had no application here because it applies to all tribes, yet not all tribes have treaties. As a fallback, the challengers also argued that, at minimum, family law is an area of exclusive state authority. The challengers' broadest arguments were radical. If those arguments had succeeded, it would have affected a monumental transfer of power from the federal government to the states. As to equal protection, the challengers advanced similarly broad theories. The Supreme Court has long held, most notably in the case Morton v. Mancari, that tribal classifications are political classifications and thus subject only to rational basis review. The challengers, however, sought to upend this framework. Though they did not ask the courts to overrule any of its precedents, they argued that tribal classifications are actually race-based and presumptively unconstitutional. The challengers also attempted to create new artificial limits on Mancari's scope, arguing, for instance, that the Mancari framework applies only on or near Indian lands and only in matters that implicate tribal self-government. The challengers' race-based arguments flew in the face of well-established equal protection principles. The very text of the Constitution singles out Indians for special treatment, and tribal classifications turn on political relationships, not racial ones. They turn on the political relationship between a tribal citizen and a tribe, and the political relationship between the tribe and the federal government. Meanwhile, tribal citizenship does not neatly correlate with race. Many people are Native American racially, but not eligible for tribal citizenship, and some people are not racially Indian, but nevertheless are tribal citizens. So for those reasons, the challengers' broadest attacks were wrong. And the challengers' artificial limits on Mancari were likewise baseless. Congress has from the beginning legislated with respect to tribes and their members, wherever they may be found. And as for tribal self-government, ICWA, by keeping Indian children within their homes, does advance tribal sovereignty. It protects the integrity of Indian tribes and families. So what happened in the case? Well, the court, by a vote of 7-2, roundly rejected the challenge to ICWA's constitutionality. Justice Barrett wrote the opinion for the court. She was joined by Chief Justice Roberts and Justices Kagan, Sotomayor, Gorsuch, Kavanaugh, and Jackson. On Article I, the majority determined that Congress possessed the authority to enact ICWA. It recognized that in a long line of cases, the court has characterized Congress's power to legislate with respect to Indians as plenary and exclusive. And the majority traced this authority to a number of possible constitutional sources, including the Indian Commerce Clause, the Treaty Clause, the Constitution's structure, the Constitution's adoption of pre-constitutional powers necessarily inherent in any federal government, and the trust relationship between the United States and the Indian people. The majority observed that the court has not doubted Congress's ability to legislate across a wide range of areas, including criminal law, domestic violence, employment, property, tax, and trade. And though true, the court did characterize its precedents in this area as unwieldy, and it stressed that Congress's powers here have limits. Despite that, the court emphasized that 2 centuries in, the slate in this area is not clean. And it concluded that the challengers failed to offer a coherent theory for why Congress could enact all those other Indian laws, but not ICWA. The court thus upheld the Fifth Circuit's conclusion that ICWA is consistent with Article 1. The court then turned to the anti-commandeering arguments. I'll not dwell here, as again, anti-commandeering is generally not a central issue in the field of Indian law. But the court stressed 2 main problems with the challengers' anti-commandeering theories. First, a law comports with the 10th Amendment when it applies even-handedly to both states and other actors. And in the case of ICWA, it does just that. Most of its commands apply not just to states, but to any party who initiates an involuntary child welfare proceeding, which sweeps in private individuals and agencies in addition to state officials. And second, there are a few record-keeping obligations that apply only to state courts, but such requirements are in fact permissible under the 10th Amendment. Finally, the court turned to standing and found that the challengers lacked the ability to pursue their facial federal claims in the equal protection and non-delegation spheres. ICWA, the court explained, is implemented by state officials, not federal ones, and the challengers had not sued state officials. Thus, the individual challengers failed to show redressability. And as to Texas, the court emphasized that Texas lacks equal protection rights of its own and cannot bring a parents patriae action against the federal government. The court thus found the claims brought by both sets of challengers failed. Now, there were 4 separate opinions. First, Justice Gorsuch, joined in part by Justices Sotomayor and Jackson, concurred to elaborate further on the sources of Congress's authority over Indian affairs and the tragic history that necessitated ICWA's enactment. Then Justice Kavanaugh, writing solely for himself, expressed the view that the equal protection issue is serious under the court's existing precedents. He suggested the court should take up the equal protection question in a future case where a challenger has standing, such as a case arising out of a state court foster care or adoption proceeding. Justice Thomas penned a solo dissent. He largely reiterated the points he made in his previous separate opinions on this subject. He stressed that he views Congress's powers over Indian affairs as limited. And finally, Justice Alito also wrote a solo dissent. He believed the challengers were correct that family law falls outside of Congress's plenary power over Indian affairs. Now, before I wrap up and open it up to a broader discussion, what does this case mean for the future? Well, while I'm a biased commentator, I think BRACKEN is one of the most important Indian law cases we will see in our lifetimes. This case was profoundly important for 2 reasons, which we've already touched on, but I'll reiterate. First, ICWA itself is one of the most critical Indian law statutes that Congress has ever passed. And second, the scope of this case was extremely broad. The challengers essentially wanted to litigate the constitutionality of federal Indian law itself. Now, precedent was clearly on our side going in, but many were unsure whether the court would stick to its past cases. There had been almost complete turnover on the court since it last engaged directly with these fundamental questions. And after Dobbs, I think everyone watching the court this term wondered whether and when the court would be willing to reconsider old decisions. BRACKEN, I think, makes clear that Indian law is not an area where the court is looking to overturn its precedent. To be sure, Justice Kavanaugh writes concurrence suggesting that ICWA poses an equal protection problem, but no other justice joins that opinion. Moreover, Justice Kavanaugh did not invite a full rethinking of the Mancari framework. Rather, he suggests ICWA might violate equal protection under the court's existing precedents. Now, I think he's wrong about that, but even then, he limits his inquiry. So at a high level, I think that the court has more or less shut the door on arguments that attack the constitutionality of all of federal Indian law and policy. There will, I'm sure, continue to be questions about whether a particular piece of future legislation or a particular application of an existing law falls within Congress's power and comports with equal protection. But compared to what was at stake in BRACKEN, such questions will be on the margins. The constitutionality of the core of federal Indian law and policy, I believe and hope, is now settled for a long time to come.
Thanks so much, Lenny, for that background. Also, your ability to break down this very complex case with many issues. so eloquently. We really appreciate that. I want to turn to the panelists, our advocates and scholars, to just provide any reflections or comments or discussion. See if you have anything to add. Who wants to start? I know you all have thoughts.
Yeah, well, I'll start with a question to my fellow panelists. I mean, to me, kind of the big, I agree with, Lenny's assessment. Obviously, it's a huge historic win in protecting, protecting really, as you said, a lot of federal Indian law from these broad sweeping arguments trying to change things. But, the big remaining issue, right, that Kavanaugh foreshadows, right, the equal protection challenge out of a state case. I know you guys were closer. Obviously, there's not a lot to go off in the opinions given the standing ruling and only Kavanaugh joining his. But from argument, was there some tea leaves to be drawn amongst? Obviously, we still, he's got to get to 5 justices. I'm counting the 3 liberals and Gorsuch maybe. So you still need a 5th vote. If and when that case comes back, works its way back up to the Supreme Court. Were there thoughts on who that 5th justice would be to protect ICWA against that equal protection challenge if it reemerges in the coming years?
I can go first and say that, obviously Barrett wrote this opinion and Roberts did not join Kavanaugh's concurrence, stressing the potential equal protection problems when easily he could have. So I infer, especially from Roberts' decision, that there's not. I don't know how he would rule if it came up, but I at least don't see him having a large appetite for these questions. At oral argument in particular, there was a lot of focus on some of the most outlandish hypothetical applications of ICWA. But, ICWA is a law that's been around for 45 years. And people started challenging its constitutionality on day one. I think there was a reason that the challengers tried to bring this facial challenge that they lacked standing to bring, which is you can come up with theoretical applications of this law that seem maybe to be troubling, perhaps even not to comport with not even to pass the very deferential rational basis test that Mankari instructs we should use. But day in, day out, I think that ICWA just is applied in very sensible, straightforward, core ways that don't make for compelling equal protection arguments before the Supreme Court. And I think that, I'm hopeful we're just not going to have to see how Roberts and Barrett would address equal protection in a state case, because they're not going to find a state case that they really think is worth their time.
I think that's very interesting, Lenny, because right after the decision, I think the lead attorney for the adoptive parent basically made a statement that was in the papers that said that they would challenge, I don't know, that he would challenge this issue in state court. So I know on the ground, Erin, you might have some thoughts about this, like there are a lot of challenges that are trying to make their way up. And this was the ultimate, right? Like what people have been working on over the years, trying to challenge the constitutionality of ICWA. But it seems like even though this was unsuccessful, that there may be, or they will be, we should be anticipating additional challenges.
Yeah, exactly. Thank you so much for that. Yeah, BRACKEN is the 3rd federal court challenge that the same constellation of ICWA opponents have brought over the course of the last decade. And I don't think anyone who was involved in this case expected or expects them to stop with BRACKEN, even though it was as Lenny said, just a tremendous win for tribes and for the rule of law and for stability of child welfare. the universe of child welfare. So we are fully expecting them to bring additional challenges in state courts. They're very well resourced and very motivated. One thing I would mention is that the same attorneys who were representing the BRACKENs in this case are involved in a case out of Washington State that is not an Indian Child Welfare Act case. It's a gaming case where they are making the same type of equal protection arguments. And so they're trying to advance those anti-tribe equal protection arguments in other litigation. And then, I mean, this topic too, I mean, there's a lot of things, many things you could say about this case and all of the issues at play. But on this issue, I always like to note for folks that to me, the equal protection conversation really kind of highlights the manner in which this was not a case of really about Indian children or about ICWA, but instead was about a broader agenda to weaken the relationship between tribes and the federal government and to weaken Congress's power. And I say that because the groups that are involved in challenging ICWA and who claim that ICWA is a race-based law are not active in Congress, in advocating to Congress or advocating before state legislatures to take the core provisions of ICWA that make it best practice in child welfare, which is kinship placement, right? And to expand those provisions to all children, which is a possibility. And I say that to say that if you are concerned that Native children are sort of getting these extra benefits from this law, one of the ways you could address that is to raise those benefits, right? Raise all boats for all children to receive those extra active efforts, rather than focus on tearing down these specific provisions that exist for the benefit of Indian children because of Congress, acknowledging the long history of Indian child removal. So I think that this, I could go, I'll stop there about just to be succinct about it. I think these conversations about equal protection really highlight how this case isn't really about broader conversations about what's best practice in child welfare, but are instead aimed at other more fundamental changes that some of these litigants are after.
Thanks, Erin. Does anyone else have any thoughts, reflections, comments, questions with regards to BRACKEN? Hey, well, we appreciate this discussion, Lenny. I know that there's a lot of people on the ground across the country who appreciate the efforts to protect the right of Indian tribes and Indian children to be raised in their communities and by their families. And I think on the ground, we see, that already ICWA is a great tool, but it isn't always applied correctly. So hopefully there'll be a lot of education about the constitutionality of ICWA at the lower courts, and that the efforts to dismantle ICWA in the future will have the same effort to protect it. And I just want to acknowledge all the work that has been done, and then note, Erin, that you were represented a number, like hundreds of tribes, which is like a pretty remarkable thing to have that many tribes join on to an amicus brief. I don't know if you can kind of just talk about that, because I think I don't think there have ever been that many tribes join onto one amicus brief.
Yeah, no, you're right. I mean, it's our understanding that the tribal amicus brief in the merits phase before the Supreme Court in this case was the most tribes that had ever signed on to one brief together. So we had 497 tribes, and actually would have had more if we hadn't rubbed up against our printing deadline for the brief. But I think it really speaks to Indian countries' unity on this issue in protecting ICWA and standing up for their citizen children. And, you know, tribes submitted amicus briefs in the 2 previous federal court challenges to ICWA that I mentioned, and then at every step of the way in BRACKEN as well. And every round of briefing as the case progressed had more and more tribes sign on. And you know, I think too, for folks, I think got the link perhaps to all of the briefing in the case. You can find it on the Tribal Supreme Court Project website, or also on Turtle Talk. But there was in addition to tribal support, just an upswell of tremendous support for ICWA from folks with lived experiences, child welfare experts, physicians, Indian law experts, historians. A wide group of allies came in to support the law. So I would encourage folks to look at all of those briefs if you're interested in learning more about the specific arguments that Lenny was discussing in detail, or the history of Indian child removal at the hands of the federal government and state governments that Justice Gorsuch went into detail in his concurring opinion on.
Yeah, and there's a question in the chat that I'm just going to bring forward to see if any of you want to answer it, but it's, what impact could Kavanaugh's concurrence have on Mankiri in terms of future cases, especially in the area of Native preference and specifically 8A contracting for Alaska Natives and Native Americans? Does anyone have any thoughts on that, or how it might be used?
I'll say that, you know, if I were someone who was trying to attack tribal rights on equal protection grounds, I would cite that opinion at every opportunity that I get, but it ultimately says almost nothing at all. It just says, really, under existing equal protection problems, maybe there is, under existing equal protection precedents, maybe there is a problem with ICWA here, and we should consider taking it up. It's pretty hard to sort of leverage that into substance. It's really just, I think it's an opportunity to flag for lower court judges, like, well, there's one justice that maybe thinks you should pay attention to these issues. That said, you know, I haven't seen lower courts eager to start questioning Indian laws on equal protection grounds. The DC Circuit issued its opinion in a case about the Seminole Tribe of Florida Compact, West Flagler litigation. They considered an equal protection challenge to IGRA in that case, and I think they might have literally resolved it in just a single paragraph. And it was a panel with both liberal and conservative appointees. They just did not seem to think there was any there. And that post dated BRACKEN.
Yes, thank you. You want to add something, Matthew?
Yeah, I think what Lenny just said is absolutely right. But if you really want to delve deep into what the meaning of that special concurrence is, it's probably helpful to go through oral argument. And Justice Kavanaugh asked a lot of very specific questions, hypotheticals. Other justices did the same. I personally think Kavanaugh was, and probably some of the other members of the court, were misled by the briefing in the case from Texas and the BRACKENs, and probably the news reporting, which made it seem like this really was the vehicle to challenge all federal Indian law on equal protection grounds. And those of you on the ground in ICWA cases know that the opportunity to get a vehicle to do that directly in an ICWA case is extremely difficult. They've been trying since 2015, dozens and dozens of cases, and they haven't found a vehicle they can put in front of the court. And it's going to be hard. It really is. And that's a good thing for us. I think if there is a vehicle to challenge Indian law or any statutes under equal protection grounds, it's probably not going to be an ICWA case. It's probably going to be a Major Crimes Act case or something like that.
Yeah, thanks very much. Thanks for this discussion. I just want to note that the ABA did file also an amicus brief in this case because there was ABA policy that was passed, and we'll put that in the chat as well. Okay, so we're going to move on with our discussion. I'm going to turn it over to Shah to discuss Arizona versus Navajo Nation.
Thanks, Patty, and thanks for having me. It's great to be here. If I can actually go just a little bit out of order and pick up off of one of the questions in the chat, which was whether there's whether anybody has a unified field theory on Justice Barrett that can explain why she votes the way she does in Indian law cases. Not to keep everybody in suspense, I do not have a view of her unified theory if she has one. I think that's partly a function of the fact that she's only been on the court for less than 3 years, so we're dealing with a limited data set. I also think it's partly a result of her style as a justice. While it is always dangerous to try to definitively ascribe positions to justices based on what they say at oral argument, I do think some of the justices, more than others, are inclined to ask questions at argument that really express a view. Justice Barrett, I think her style, at least in my experience arguing before her, she tends to ask questions of both sides that are really going to help her resolve the case, but that don't necessarily purport to express a unified theory. And then in a number of the Indian law cases, including the Navajo Nation case, which I'll talk about, I think a lot of people who observed the oral argument thought that she would be the swing vote. She did not write separately in that case. She joined Justice Kavanaugh's majority opinion, which we'll talk about in a minute. But unlike Justice Thomas, unlike Justice Gorsuch, in her time on the court, she really hasn't staked this out as an area where she's really expressed a theory or written concurrences that stake out her own voice in this area. So I think she's a critical vote in this area, but unfortunately, I don't have a unified theory, and I think she may well have been a critical vote in the Navajo case, but what ultimately drove her vote, we don't really know. So picking up on that question and talking a little bit more generally about the Navajo case, as Erin said earlier, different people on the webinar may have different backgrounds. So just to start out at a high level, the Navajo Nation's water needs are quite dire. More than 30% of households on the Navajo reservation lack running water. As Justice Gorsuch wrote in his dissent in this case, in some parts of the reservation, as many as 91% of Navajo households lack access to water. Members of the Navajo Nation use around 7 gallons of water per day for all of their household needs. The average American uses about 80 to 100 gallons per day. So just a huge disparity. Many Navajos also have to haul water from miles away. That's not just time consuming and exhausting, it's also expensive. Hauled water can cost up to 20 times more than water costs in neighboring communities outside the reservation. And of course, if you follow the news, you know that drought conditions in the West generally make all of these problems even more severe. So against that backdrop, the Navajo Nation believed that the United States has treaty obligations to ensure that the reservation has enough water to be a permanent home for the Navajos. But the United States has long ignored the Navajos' lack of water and need for it. And so the nation brought a lawsuit to hold the United States to its treaty obligations. Stepping back, because I want to talk about a couple of legal principles that are important for understanding this case. One is the Winters Doctrine, and the other is the law governing the Colorado River. So with respect to Winters versus United States is a 1908 Supreme Court case that was really at the center of this Navajo Nation case. In Winters, that case involved a water use dispute, and the court there was interpreting an agreement between the US government and a tribe. And the court held there that when the United States reserves lands for an Indian reservation, it also reserves then unappropriated water sufficient to satisfy the purposes of the reservation. Now, that doesn't mean that the government physically takes control of the water or actually puts it aside. It just means that when the government reserves the land, it's also reserving rights to however much water is needed to satisfy the purposes of the land. And this Winters rule now applies to all types of federal reserved lands, including Indian reservations, but also including national parks and monuments. So that's one piece of background. Second piece of background relates more generally to the Colorado River. The Colorado River, of course, is very important in the arid Southwest. It's divided between the upper basin and the lower basin. The 1928 Boulder Canyon Project Act authorized the construction of the Hoover Dam and gave the Secretary of the Interior the authority to allocate the water of the Colorado River among the lower basin states. The lower basin states continued to disagree, and in the 1950s invoked the Supreme Court's original jurisdiction. That led to the Arizona versus California litigation, which was about how water from the Colorado River mainstream would be allocated. The parties to that litigation were the lower basin states and the federal government. And critically for this case, the federal government in Arizona versus California brought claims on behalf of some tribes to the mainstream, but not on behalf of the Navajo Nation. And in fact, the Navajo Nation tried to intervene in Arizona versus California, and the United States opposed the nation's intervention, saying that the United States spoke for the Navajo Nation in connection with its water rights. The Supreme Court issued a decree in 1964. It allocated water among the states and the tribes that the government had asserted claims for. And the decree said that the court retained jurisdiction, quote, for the purpose of any order, direction, or modification of the decree. And so as a result of that, the Supreme Court, only the Supreme Court through the Arizona versus California litigation can ultimately change the allocation of quantified water rights to the lower Colorado River. So against that backdrop, the Navajo Nation brought this case back in 2003. At the center of this case is the 1868 treaty between the Navajo Nation and the United States. The treaty established the Navajo reservation and promised the Navajos would have enough water to make the reservation their permanent home. Now, that permanent homeland language is the same language that in the Winters case that I described, the Supreme Court held triggered the reservation of water rights at issue there. So the treaty established the Navajo reservation and promised the Navajos a permanent home, but the United States has never lived up to that promise in connection with water. Again, as I described the Arizona versus California litigation, when the US government and Southwestern states went to the Supreme Court beginning in the 1950s to divvy up rights to the lower Colorado River, the United States shut the Navajo Nation out of that process. The nation brought this lawsuit to hold the United States to its treaty promise and specifically asked the government to assess the reservation's water needs and develop a plan to meet them. Again, just to underscore the relief that the Navajo Nation was seeking here, it was to assess the reservation's water needs and develop a plan to meet them. The Ninth Circuit held that that claim could proceed, but the Supreme Court granted cert and by a 5-4 vote reversed. The opinion was by Justice Kavanaugh, joined by the Chief Justice, Justice Alito, Justice Thomas, and Justice Barrett. Justice Thomas wrote a concurrence that I'll talk about in a minute, and Justice Gorsuch, along with Justices Sotomayor, Kagan, and Jackson, dissented. The main point, I think, of the majority opinion is that while the 1868 treaty establishing the reservation reserved necessary water to accomplish the purpose of the reservation, it did not require the United States to take affirmative steps to secure water for the tribe. And under that rule, that in the majority's view, the United States had not agreed to take affirmative steps to secure water for the tribe, the United States was not obligated to provide the Navajo Nation with the relief that it sought here, which was an assessment of the water needs and a plan to meet them. The majority's reasoning is that the federal government owes judicially enforceable duties to a tribe only to the extent that it expressly accepts those responsibilities. And that inquiry in turn has to focus on specific rights creating or duty imposing language in a treaty, statute, or regulation. The 1868 treaty, the court held, doesn't contain any language that specifically imposes such a duty. At the same time that it does impose a number of other specific duties on the United States, it just doesn't say anything specifically about a duty with respect to water. That was the majority's basic reasoning. The Justice Thomas concurred in the majority opinion, but also wrote a separate concurrence questioning really whether the court has gone off track in recognizing a trust relationship between the federal government and Indian tribes to begin with. And Justice Gorsuch dissented. I'll talk a little bit more about that in a minute. There are some silver linings, I think, to the court's 5-4 majority opinion, even though it didn't reach the result that we were hoping for on behalf of the nation. One is that the court reaffirmed Winters. Winters really was a landmark case, recognizing, again, that when the federal government creates an Indian reservation, it's also reserving water rights to go with the land. I think there was some concern heading into this case that perhaps the Supreme Court would jettison Winters altogether. But the majority opinion doesn't do that. It reaffirms the Winters doctrine, it reaffirms the vitality of the Winters doctrine. In addition to that, the court specifically held that under the 1868 treaty, the Navajo reservation includes not only land within the boundaries of the reservation, but also water rights. And so, as the dissent emphasized in this case, but I think all 9 justices agreed on this, quote, everyone agrees that the Navajo received enforceable water rights by treaty. Now, to me, this is now just my personal opinion, it is at best anomalous to say that a treaty creates enforceable water rights, but that there is no correlative duty to actually carry out that promise in a breach of contract sort of situation. And ultimately, a treaty is a contract between 2 parties. If one party promises something to the other party, the other side has an accompanying duty to deliver on that promise. So it is at best anomalous to say we have a promise of water rights under the treaty, but there's nothing that the United States has to do in order to carry out that promise. But that, I think, essentially is the line that the majority drew here. It is at least a silver lining, though, that the court reaffirmed Winters and recognized that under the 1868 treaty, the Navajo Nation specifically has water rights. The court also, it's also important to note what the court didn't decide. The court didn't decide whether the Navajo Nation has rights to the Colorado River or to any other water source. The court's narrow decision here was only that this particular lawsuit couldn't move forward. But again, the court didn't resolve whether the nation has rights to the Colorado River. And in fact, it suggested that the nation could try to protect its water rights by bringing different challenges in court. The majority wrote, quote, "The Navajos may be able to assert the interests they claim in water rights litigation, including by seeking to intervene in cases that affect their claimed interests." The dissent went even further. Because the United States has for decades refused to help the nation and even shut the nation out of the Arizona versus Colorado litigation, the dissenting opinion wrote, quote, "After today, it is hard to see how this court or any court could ever again fairly deny a request from the Navajo to intervene in litigation over the Colorado River or other water sources to which they might have a claim." Lastly, the court also made it clear that the political branches can help the Navajo Nation secure the water that its people need. I remember at oral argument, I was asked this question by one of the justices: why can't you just go to Congress and have Congress solve this problem? Of course, we've been waiting 50 years for Congress to solve this problem, and it hasn't happened. And again, in our view, the treaty already addressed this. Lastly, let me just close with a quote from the dissent, which I think is really powerful. I think that the dissent did an excellent job setting the historical record straight and underscoring some of the injustices that the Navajo Nation has suffered at the hands of the federal government. The dissent wrote, quote, "The Navajo have tried it all. They have written federal officials. They have moved this court to clarify the United States' responsibilities when representing them. They have sought to intervene directly in water-related litigation. And when all of those efforts were rebuffed, they brought a claim seeking to compel the United States to make good on its treaty obligations by providing an accounting of what water rights it holds on their behalf. At each turn, they have received the same answer: try again. So while it was a disappointing result in this particular case, I do think there are a few silver linings here in terms of reaffirming the Winters Doctrine, recognizing that the 1868 treaty does give the nation water rights, and recognizing that there may be other avenues, including intervening in litigation where the Navajo could pursue their rights, even though this particular kind of claim seeking to hold the United States to its duty to perform an accounting and come up with a plan was ultimately not successful.
Thanks so much, Shah, for sharing that perspective, for breaking down the case for us. It is great that there's a silver lining. I will say this case is particularly heartbreaking, with regards to the present and the future. When you see the statistics that you shared about the lack of access to water, and we saw during COVID how Native people were disproportionately impacted, especially when they didn't have water access. So yeah, I appreciate those thoughts. I'm wondering if anybody on the panel has any reflections or questions or comments for Shah. Okay, well, thank you, Shah. Well, I appreciate that. I know that Navajo is engaged in litigation stateside that's going on for a number of years, and I think just practically having a right and recognizing that right in the treaty, like, I'm sure that they're going to be looking at how do we obtain, they'll be continuing to look about how to obtain these rights. One question that's asked that I will pose to you is, what do you think about the loss of any fiduciary trust responsibility in the Navajo Nation case?
Well, so I think first of all, I take some comfort in the fact that nobody joined Justice Thomas's concurrence, which suggested doing away with any sort of a trust relationship at all. So there was only one vote for that. And look, as I said in my comments earlier, while I see a silver lining here, I do think that the court was wrong in holding that there are water rights, but that there is no fiduciary duty on behalf of not just a contracting party, but the United States in the context of a treaty with an Indian tribe to carry out its side of the bargain. So, I mean, I do think that is, I think that's wrong. I think that is a significant error by the court, but I take some comfort in the fact that the court wrote the opinion narrowly enough to leave other avenues for the Navajo to pursue. And again, that the court here did not determine that the Navajos lack water rights to the Colorado River. To the contrary, the court found that the 1868 treaty does create water rights.
Yes, great. Well, thank you, Shah. We appreciate that. And we appreciate your perspective and your work on this case on behalf of the Navajo Nation and all of Indian country, especially with regards to water rights. It's so important to the future of Indian country. All right, now we are going to turn to Pratik Shah, who will be discussing Lac de Flambeau.
Thank you, and thanks everyone for joining this session. I'm learning a lot, and hopefully I could share a little bit with you about the Lac de Flambeau case. The question presented is fairly straightforward and in some ways simpler, both factually and legally, than the other two cases that we've discussed, in that it's just really a single straightforward question, which is whether the bankruptcy code abrogates the sovereign immunity of Indian tribes. How did this case get to the Supreme Court? It arose from a single plaintiff who filed for personal bankruptcy, and his claim was that the tribal lending company continued to contact him to collect the small loan, about $1,000, despite repeated notice of the automatic stay. So when you file for bankruptcy, there's supposed to be a stay or a stoppage of all collection claims. And he says, look, the tribal lending company continued to call to try to collect this debt. He says those collection efforts caused him severe emotional distress, and that precipitated him suing in the bankruptcy court the tribe for the violation of the automatic stay for hundreds of thousands of dollars in damages. Now, the facts of this case really didn't loom large at argument or in the opinion. Justice Alito asked whether this was a true tribal corporation. Clearly, I know where he was going, but we were ready for that line of inquiry, and that was quickly shut down because LDF's business is a true tribal operation headquartered on the reservation, and that issue didn't surface again either at argument or in the opinion. The bankruptcy court dismissed the plaintiff's claim against the tribe as barred by sovereign immunity, tribal sovereign immunity, but the First Circuit, in a divided opinion by Judge Lynch, reversed. And that added to the circuit split, the split amongst the circuits on whether, in fact, tribal sovereign immunity applied under the bankruptcy code. So as it came to the court, it was really just a pure question of statutory interpretation. And there's kind of two related provisions of the bankruptcy code, which are pretty straightforward. The first is section 106A of the bankruptcy code, and it expressly and clearly abrogates the sovereign immunity of governmental units. Then section 10127 in turn defines a governmental unit and has a specific definition. It's a defined term, and it defines it as the United States, a state, commonwealth, district, territory, municipality, foreign state, department, agency, or instrumentality thereof, or other foreign or domestic government. So notably, given the omission of Indian tribes from that list of enumerated entities whose immunity would be abrogated, the question was whether the Indian tribes fall within that residual clause at the end, after naming all of the other entities under the sun that have sovereign immunity. I don't think there's really anything left. The question is whether that residual clause, other foreign or domestic government, captures Indian tribes and captures it unequivocally, given the clear statement rule that Erin mentioned at the beginning of this webinar. So an important premise here of this case, and I think it's important if we're talking about silver linings, it was an important premise that all parties agreed that the clear statement rule applies. Right, this isn't one of these cases where the challengers, as we've seen in Bay Mills or other cases, where they're challenging the application of the clear statement rule. And under the clear statement rule, Congress must make its intent unmistakably clear in the language of the statute. That's what Supreme Court case after case has said. And so it should be that any plausible reading of a statute to preserve tribal sovereign immunity must be accepted. Now, in light of that agreement amongst the parties, the court did reaffirm the clear statement rule. All of the justices agreed, I guess I should say 8 of 9, because Justice Thomas, of course, wrote separately. But despite the agreement that the clear statement rule applied, the court, and this was in opinion by Justice Jackson, joined by all other justices except Justice Thomas, who I mentioned concurred separately, and Justice Gorsuch, who dissented, held that Congress met the high bar of the clear statement rule in the bankruptcy code. The court essentially held that the code unequivocally, those provisions that I read you, unequivocally abrogate sovereign immunity of any and every government that has the power to assert it, and therefore would also include tribes. And I guess there were 3 parts, I would say, to the majority's opinion, although it wasn't all that long, just 15 pages. It reads the catch-all phrase, or what the majority describes as the catch-all phrase, I would call the residual clause, other foreign or domestic government, as broadly covering any and every form of government, The majority analogizes it to a phrase like day or night, right? It's meant to cover the entire field. And that, we admitted willingly that that's a perfectly plausible interpretation of the language. Maybe it meant that, but it wasn't certainly the only plausible reading of that residual clause, other foreign or domestic government. And I think we emphasize that, look, Congress provided an enumerated list from which tribes are a glaring omission. There's only, United States, states, tribes, throw in maybe territories that have sovereign immunity. It's a pretty glaring omission to have that. So why use a residual clause to capture the only other entity entitled to sovereign immunity? We also emphasize the court's own precedents that long described the tribe's unique status as neither purely domestic nor foreign, right? Tribal status is sort of sui generis under the Constitution, under the court's precedents. So we thought it was a close call without the clear statement rule, but that we had, under the clear statement rule, the tie should have gone in our favor. But of course, the court held differently and found that that broad language was unequivocally broad. Now, the court did acknowledge our argument that Congress has never chosen to abrogate tribal sovereign immunity without any mention of tribes whatsoever in the statute, but it rejected that unbroken practice as a sort of magic words test. Obviously, we disagreed with the characterization that we were advocating for a magic words test. We were advocating for what we thought was a pretty common sense principle, that when Congress has been doing something for over a century and has done it one way, when abrogating tribal sovereign immunity, that a court might want to take that into account in construing the statute and deciding whether it unequivocally was abrogating sovereign immunity by using this new and, in our view, not unequivocal language. The third point that the majority made was, look, there's no explanation of why Congress would have wanted to exclude Indian tribes under the bankruptcy code, or the exclusion of the abrogation of the sovereign immunity of Indian tribes, just like it had abrogated the sovereign immunity of the United States and states. But of course, the Supreme Court precedent is also pretty clear in the clear statement context, as recently as Bay Mills, saying that the purpose, whatever the purpose might be, shouldn't trump the plain language and structure in a clear statement case. And on top of that, we pointed out that under the pre-1978 code, that is the bankruptcy code, the statute that preceded the bankruptcy code in front of the court, which did not have a specific definition of governmental unit, it had the same anomaly. That is, it treated United States states differently than Indian tribes in several ways, and that was largely undisputed. So it may have been, and we pointed out, it may have just been the fact that Congress didn't focus on the issue. Of course, we don't know, but in light of that silence or ambiguity, once again, under the clear statement rule, it should cut in our favor, not in the plaintiff's favor. Now, Justice Thomas, as I mentioned, did write separately. He didn't join the majority, but concurred in the judgment. And he basically reiterated his position from Bay Mills, and I'll just quote it, that, quote, to the extent tribes possess sovereign immunity at all, that immunity does not extend to suits arising out of a tribe's commercial activities conducted beyond its reservation, end quote. So again, this is Justice Thomas out on his own. Thankfully, as in Shah's case, no other justice joined that separate opinion, but he has maintained his much broader positions, calling into question sovereign immunity in the first place. Justice Gorsuch again dissented, as he has come to do in tribal cases. It is longer and, in my view, much more thoughtful than the majority opinion. It emphasizes many of the points that I mentioned above in response to the court's decision. I'll just give you a flavor of a few quotes. He says, quote, until today, there was not one example in all of history where this court had found that Congress intended to abrogate tribal sovereign immunity without expressly mentioning Indian tribes somewhere in the statute. And then in response to the residual clause, that phrase about other foreign or domestic government that the majority found to clearly cover Indian tribes, he says, quote, "The Constitution's text and 2 centuries of history and precedent establish that tribes enjoy a unique status in our law, neither as a," end quote, "neither as a foreign government nor as a domestic government." And he does a pretty deep dive into the precedent and points out the nuances and the many different justices over the years and opinions over the years that have struggled over the classification of tribes. Of course, not spatially, right? Spatially, they are domestically within the United States, but as a political entity, which is how one should view this language, or at least one could plausibly view this language as speaking. So, and then he says, of course, at the very least, plausible interpretation should defeat the abrogation under the clear statement rule. And he found that our interpretation to be at least plausible, if not the better one. I guess I'll just make a couple observations so as to preserve Matthew's time to kind of give us a broader insight on the term as a whole. One is that I think Justice Gorsuch continues to make his case as the most pro-tribe justice, at least in my years of watching the court in a couple decades. And I'd love to get the other panelists' take on that. The other point I'll make is the Solicitor General's office here participated in support of the plaintiff against tribal sovereign immunity, and I found that deeply disappointing. The United States has its own strong interest in a clear statement rule, not just out of the special trust relationship with tribes, but for its own sake. And yet it went out of its way to support the plaintiff in this case. I would have preferred, if it wasn't going to support the tribe, to just sit out. As far as I can tell, that would have been contrary to Department of Interior's recommendation, and yet that's what the government did. And I think, that could have had an impact on this case. And then the last thing I'll say, and I think hopefully I'd love to hear from Matthew more about this, but I think there's been progress made since Justice Sotomayor and Gorsuch's arrival, but I still think there's still much up in the air when it comes to Indian law cases at the Supreme Court, particularly with the court as it's currently constituted, of which we have, very limited data. Obviously, we have the big wins, as in the BRACKEN case, but a lot of that is holding serve, right? Preventing the court from doing damage to long-standing precedents, like preserving the winner's rule, right? That's the silver lining in Shah's case. Preserving the clear statement rule, the silver lining in my case, and of course the much bigger win in BRACKEN. But these days I think holding serve is a significant win in those terms. At the same time, you have cases like the ultimate holding in our case, where I think it came down to the court really not, at least the majority of the court, not really being able to fathom special treatment for tribes relative to other sovereigns, right? I think what this case boiled down to is, well, look, Congress abrogated the sovereign immunity of the United States and states under the bankruptcy code. Why would they have not wanted to abrogate the sovereign immunity of Indian tribes as well? And I think that that was a challenge. So I'll stop there and hand it back over to Patty and Matthew to finish up.
Well, thank you so much, Pratik. It's very thoughtful discussion of tribal sovereign immunity and impact of tribes. And just in my mind, I think, there's some, not some, but a great lack of knowledge of the court and tribes, like with regards to tribes. And, maybe there should be more education to the court outside of the term with regards to tribes and their rights, and having them understand that, because it seems like you're right. I mean, Gorsuch is the Indian law expert on the court, and there should be more education. I don't know, Matthew, if you have any reflections on this, or if, I think for time, maybe we can just move into your comments and then you can add any reflections you want on this case, or you can start with reflections on this case and then give some overall comments.
Yeah, I think that's what I'll do.
Okay.
The case came out and I went to here at Michigan, the faculty during the summer, each major case is sort of broken down in our little faculty workshops. And I just happened to be in the room when our bankruptcy professor, John Powell, talked about this case a little bit. And, some of the things he said, I don't know much about bankruptcy. They were interesting. Some things going forward now that sovereign immunity of tribes in bankruptcy cases is sort of gone that are interesting to me. So bankruptcy, property rights in bankruptcy cases are decided under state law. So, some of that might end up being bankruptcy cases are decided by a tribe's definition of a property interest. And a lot of tribes haven't thought about that. And, there's some practicalities to bankruptcy, some wrinkles to bankruptcy that nobody's really seriously considered, how it's going to impact a tribal business or tribal business activities. And, one of the big cases that's going to come out next year has to do with the Sackler family. I don't know anything about the big pharma case, but, the Sackler family is all behind the opioid epidemic in a lot of respects, but they've been able to, their company has gone bankrupt. And so what they did as a strategy is to try to sit out of that case, but they're still in it. A federal judge, a bankruptcy judge, under Section 105 of the Bankruptcy Act, can actually bring in a third party and bind them to a case they're not actually a part of. And the Sacklers are all in. They're like, well, here we have number of billions of dollars. You can have half. We'll keep the rest. We don't need all that much, and just let it go away. Just let us have what we want. And I could see a bankruptcy judge thinking, well, I've got enormous power to bring a third party in. Why don't I bring this tribe in? They don't have sovereign immunity. I can do that. And I don't know what that means. So that's sort of the frustrating element about not listing tribes and including them in a waiver of sovereign immunities, because tribes really are different than all of those sovereigns in really dramatic ways. We have treaty rights. We are separate sovereigns. We're written into the text of the Constitution, and our business interests are dramatically different than those of other entities. Foreign nations are included in this waiver, and there is a Foreign Sovereign Immunities Act that creates an entire mechanism about foreign sovereign immunity, foreign nation sovereign immunity. Congress has never passed anything like that with tribes. There's so many differences between the tribal sovereigns and bankruptcy and all these other sovereigns. So I just think it opens up an entire series of cans of worms. So it's frustrating that, but on the other hand, it's kind of understandable. The court is a policy court fundamentally, which brings me back to my overall 7 minutes of comments on this turn. So number one, Amy Coney Barrett, as she is absolutely the swing justice in Indian law right now. And she might not be writing the opinion, and we might not know why she votes the way she does, but she wasn't the only one, I think, in the majority in all the cases. And I think that's probably going to be largely true going forward. Number two, I think that we're seeing a deep split. We've always seen a deep split within the court on what its methodologies are in terms of deciding Indian law cases. I think, loosely speaking, you can divide them up into sort of three big categories. One I really like, that's where the court follows the law. It pays attention to the default interpretive rules of federal Indian law. It pays attention to its own precedents. If you read the majority opinion on congressional powers, the Article 1 part in BRACKEN, this is what I mean. They're like, we might not like it, but we've got 75 cases that all say the same thing. Congress has a significant power in Indian affairs. We're just not going to end that today. That's a very institutionalist way. I like that. We're going to lose some cases that way, but tribal interests are really strong when that is actually where the court is. But even in the BRACKEN case, there are alternate, in the majority opinion, there are alternate judicial methodologies. There's also originalism. The court actually cares what a bunch of slave-owning Indian haters, white guys who owned up all the property in the United States, they're the ones who matter in the interpretation of the Constitution. And we don't really know what they thought. They didn't write every single thought down, and they all completely disagreed on just about everything. So originalism is basically the judicial methodology that could throw the whole thing out. The true faithful originalist, to the extent that there is such a thing, and I don't think there really is probably Clarence Thomas, and he's just trying to throw all of law out the door and start over with his preferred understanding of what law is. And I'm so glad that after 20 some years of him interjecting these wild radical theories about Indian law, not a single judge has ever voted or has ever signed on to any of those, even Justice Alito, who I think is right up there with sort of a radical understanding of the law. And there's sort of like the third, to me, the scariest thing, even more scary in a lot of respects than originalism, because a lot of judges go along with it. And if you read Justice Kavanaugh's opinion in Castro Huerta, it's basically the same opinion that Bill Rehnquist wrote in Suquamish, that Justice Kennedy wrote in Duro versus Reyna. This is a completely lawless opinion that is rooted entirely in the preferences of a particular judge on questions of policy. And there's no way to argue against it. They're just, if they have the votes, they can say anything they want. And those are, to me, that is just, that those are sort of the three big sort of methodologies. And some justices bounce back and forth between all of them. And it's so hard to pinpoint, strategize what to do in a case like BRACKEN, or in a case like Kaufman, or in a case like Navajo Nation. Third big point, I really loved what has been going on for the last few years with the Tribal Supreme Court project. I think we're finally seeing the maturation of the Tribal Supreme Court project. So kudos. If you go back to Adoptive Couple versus Baby Girl in 2013, look at the number of amicus briefs. I felt it was really important on Turtle Talk to list all of the amicus briefs and what the purposes of those briefs were. And there were a long list of briefs that had no purpose whatsoever. They were repeats of other briefs. They were groups that didn't really have any stake in the case or just trying to interject something. And that number of those briefs, and by the time 10 years later, we have BRACKEN, dropped dramatically. I mean, it was a much bigger case than Adoptive Couple was, which was a statutory interpretation case. BRACKEN was everything. We had far fewer briefs. They were almost all of them were very targeted, very specific to the strategy. Whether you agreed with the strategy or not, at least there was organization to the strategy on the side of tribal interests. And that, to me, says a lot. Since 2014, tribes, in sort of these cases, I count 11 wins out of 17 cases, which 11-6 is pretty solid, but it's not perfect, but it's by far the best in the history of the Supreme Court with tribal interests over an extended period of time. And 10 years really isn't even that many years. There are consequences, negative consequences to the Supreme Court project. Most notably, no Native person has argued an Indian law case or any case since 2001, Nevada v. Hicks. And only one woman has argued a case on behalf of tribal interests. And I'm proud to say my brother, Zeke Fletcher, hired Patty Mellett to argue the first Patch Act case, which unfortunately she lost, not her fault. But that's the only woman even who has argued a case for tribal interests over the past 20 odd years. And I guess I'll conclude with a continuing rant that I always have. I've been talking a little bit about some of the answers in the Q&A. A lot of Indian law is dominated by the unelected officials, not just on the Supreme Court, but in the Office of Solicitor General. And I wish I could say that there was a rhyme or a reason to positions that the SG takes. I completely understand Pratik's deep concern about why the SG decided to file a brief and argue against the tribe's interests in the LDF case. Who knows? That the government decided not to intervene in Little Traverse Bay Band's reservation boundaries case, which was one of the strongest cases I've seen. They just sat that one out, which was a strong signal to the federal judge that the tribe was going to lose. And that's exactly what happened. We have no idea. And Lenny has pointed out, nobody that we know of who's Native has ever worked in the SG's office. I've actually been told, my wife and I have been told in my face over a couple of martinis, mind you, by a member that somebody who worked from the SG for a long time. We're not going to hire Native people. They cannot be trusted to be objective in an Indian law case. And they're just not going to do it. So I don't know. That's not a representation of policy at all, but it's a concern. And I find the SG's sort of tail wagging the dog on a lot of Indian law cases to be really, really frustrating. I'm at my time, but there are cases that we have to watch. We've talked about them. Anytime there's a sovereign immunity case where a tribe is one below, the court's going to look at that really carefully. I thought the Coughlin case was a bit implicitly suggested that when we finally get a case that's going to determine whether federal statutes of general applicability that are silent as to tribes actually apply to tribes. Coughlin suggests that the answer is going to be yes, at least in instances like the bankruptcy area where the Congress has really stepped in and completely dominates, preempts a field, and fully expect a lot of equal protection challenges. As I said before earlier, I think that's probably going to come in the criminal justice area first, because there are so many of them and there are so many vehicles for the possibility of that. And I think that's a really good thing for tribal interests, because one of the things I firmly believe the Supreme Court does not want to do is to undermine the Indian country criminal justice regime. And I kind of think, I will always think until somebody tells me differently, that's why the Supreme Court upheld BRACKEN. So I'll stop there.
Wow, that was awesome. We appreciate everyone's reflections and thoughts. I think this was a great discussion. I appreciate, and the ABA section on civil rights and social justice, appreciate all of you participating in this webinar. I think it's fantastic. I want to thank Matthew for answering many of the questions in the Q&A. So we appreciate that. This is recorded, so people who are not participating will be able to see it later. And we just want to thank you for all of your work and wish everyone the best for the rest of the day. So thanks, everyone.